Good morning, Kent Meyer, Traditions Law, with another of Dr. Meyer's prescriptions for estate planning. Now remember last month, we began our discussion of trust administration. We talked about how important it was that at the first death, certain actions be taken in order to make sure that there are not problems for yourself, for the surviving spouse, or your heirs down the road. So today I would like to continue our discussion of trust administration. Remember what last time I said that this is an area that is often neglected, and sometimes it is undertaken by the surviving spouse or by a successor trustee without legal assistance. Let me give you a word of caution here. Do not try to administer a trust yourself, either as a surviving spouse or as a successor trustee. The number of nightmare stories I can tell you that have resulted from that kind of action or inaction would maybe amaze you. So you don't want to be in that situation. So what happens when in a married trust, both spouses are gone? Now, this would also be the same thing, of course, if you had a single trust and now the single settlor of the trust dies. Okay, so what happens at the second death? Well, first of all the actions that were done at the first death with regard to sending notices, with regard to sending information to beneficiaries, and in this case, beneficiaries in particular are given a notice that the decedent has died and they are now beneficiaries of a trust. They can then say, well, I want to see a copy of the trust. So the beneficiaries are now entitled to a copy of the trust as it relates to them. This is a step that's very important, often neglected, and it can create a lot of problems. Now, the beneficiaries will receive notice of the death. They can then decide whether they want to waive an accounting, whether they want to waive the statutory period to dispute the trust. Now, by statute, they're given 3 years to dispute the trust. Well, many people don't want to wait 3 years to get distribution from the trust. So initially, they are given notice that they can shorten that period to 120 days. And so that significantly reduces the time necessary to administer the trust. The successor trustee, after having notices sent, will then identify the assets of the trust and take inventory. You need to have date of death values for all the assets in the trust. That way you have a beginning point for deciding how to distribute the assets according to the terms of the trust. The trustee must follow the terms of the trust exactly. They can't deviate, they can't become creative. So it is their job to then make distributions to the beneficiaries. In some cases, if, for example, a beneficiary is a minor, the successor trustee and trust administration will manage the assets in a subtrust for that minor. Sometimes it's an incapacitated individual as well. But if the individual is an adult, then usually they get a direct distribution at a certain age. Currently, right now, 25 is the most common age for the ability to get all of the assets in the trust as their share. Finally, the successor trustee and the beneficiaries, after all the assets have been distributed, will sign a distribution and settlement agreement, which says the beneficiary's got everything they're supposed to get, and the trustee has done their job. They all sign the agreement, and then the trust terminates. So again, Kent Meyer, Traditions Law, and we discussed second death trust administration.